Welcome back to the Emily Show, and hopefully you have internet and power and all the things you need to miss this winter storm that is going to delay court a bit, I think, this week. But we have lots to catch up on, so don't you worry. The criminal docket is full today. There are some updates in the Banfield case, the au pair trial that we have been covering quickly, not gavel to gavel, but quickly on the stream. And there were some big updates Friday. So without spoilers, we're going to talk about those updates and what the plan is for streaming. So make sure you have the Law Nerd app because you're not going to want to miss this. And Michael McKee was in court in Ohio for his arraignment. We're going to take a look at that together. And then there was an arrest in the David case, the investigation into the death of Celeste Rivas. And we're going to talk about what that arrest is, what it means, and what information we learn from that. So as I said, busy criminal docket today. And hey, we need to get recording before the power goes out. So that's our goal here. All right, Law Nerds, let's get into it. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. So turning first to Ohio, Emily, we're just a podcast that's covering the McKee case. Well, now that he has been finally extradited to Ohio, and we can see the arraignment that we're going to watch together from Friday, the court dates won't be quite as fast, and I don't expect quite as many updates. Then again, criminal cases tend to surprise us, so who knows? But we will go through the arraignment. A judge has been assigned, bond has been set at no bond, and the case will begin the process of going through discovery. Remember, Michael McKee was indicted on January 16th for the double homicide of victims Spencer and Monique Tepe being his ex-wife. He was arrested in Illinois and then extradited. It took a little bit of time, but extradited to Ohio. Now, during the process of him being extradited, or while they were waiting for extradition, that indictment came down from a grand jury. So originally it had been charges and an arrest warrant, and then elevated charges, and then an indictment. So now he's being arraigned on that indictment with all of the charges that we went over last week. So we are in court in Ohio. And for those of you listening in the background, you might not see this courtroom, but the overhead lighting in this courtroom is literally my worst nightmare. Instant migraine with this one, but alas, we don't have to be in court. And you will see that the defendant is on a projector screen in the courtroom because he is in custody in Franklin County. And instead of bringing him into court, they just Zoom courted the appearance. And we will see his attorney and the prosecutor on this case in the course of this arraignment. Remember, arraignment is formally letting somebody know what the charges are against them. It's the beginning proceeding of the court case.
Can you hear us out there at the new jail?
Yeah, we got you.
I could barely hear him.
All right, you can see on the screen the defendant who is on the screen from jail. You can see that there's also a screen where the defendant presumably can see the court down at the bottom screen there.
Make your parents call your first case, please.
Good afternoon, Your Honor. Stephen Schott, Dan Leder, and Shayla Faber for the state.
So three
First
prosecutors.
Case before the court, State of Ohio versus Michael McKee. It's 26 CR 253. There are 5 counts. 4 counts of aggravated murder, unclassified felonies, and 1 count of aggravated burglary, felony 1. Each of these counts come with a 3 and a 6-year firearm specification.
Thank you. Counsel, please make your appearance.
Thank you, Your Honor. Diane Menashe on behalf of Michael McKee.
And this is the defense attorney.
Your Honor, with respect to the allegations, we would acknowledge receipt, waive reading, enter not guilty pleas to all counts contained therein. We would also waive.
We have talked about this happening in arraignments. Waive formal reading of the arraignment, waive advisements, and set the case forward because the defendant already has the indictment. So does defense counsel. You don't need to read it line by line in court. Very typical of arraignments. Arraignments tend to go pretty quickly.
We would also waive bond at this time, although we certainly reserve the right to raise that at a later date. The plea of not guilty form has been executed and signed on behalf of my client. Nothing further.
Thank you, counsel. I've signed the not guilty plea. I'm signing the bond form indicating that bond has been waived. Anything further?
No, Your Honor.
Thank you.
Thank you, Judge.
Thank you. Next case, please.
And that's it. Would I have said how arraignments go in the past? That is how arraignments go. Next case. And the arraignment court did not set a new date for this case. A judge has been assigned to it, Judge Kim Brown. and they will start picking dates together with the attorneys. And then when there is a new date, I will let you know. But for now, no bond. The defense will start meeting with their client, talking about potential defenses. The prosecution will be turning over discovery. And I am sure that there is investigation still ongoing, particularly when it comes to devices, cameras, and the rest of it. So when will the McKee case be back in court? Not sure yet, but we'll know when we know, and then I'll let you know. So if you don't have the Law Nerd app, now would be the time to get the Law Nerd app at lawnerdapp.com. So when those things happen, I can just keep you in the loop. Let's take a look at what's going on in the Banfield case in Virginia, because we have been covering this on stream, and the Law Nerds, you guys, you got me. It was not on my docket. This was supposed to be a much longer trial. It's gone quicker than anticipated, but trying to overlap this trial with the beginning of the Corey Richins trial was just going to be difficult for me because I had some unavailable dates as this trial was playing out. And then in chat, y'all were like, but Emily, it's Judge Askarati from D4vd Heard. And I was like, Judge A, you say? We'll take a look. So I have been covering that on stream, not typical gavel to gavel, witness by witness. We have summarized some of the witnesses to try to truncate some of the more slogging, painful days. This has not been a tremendously well organized prosecution. So we have looked at key witnesses. We have gone through the entirety of the prosecution's case in chief, and we are going to be starting on stream. While I presume court in Virginia is going to be closed for a few days due to the weather, we are going to be catching up on the beginning of the defense's case. On Friday, I was taking a look to see what the scheduling was going to be with court, what Judge A let the jurors know about scheduling, and there were some tidbits that we need to talk about. If you have not watched this case yet, don't worry. Now is the time to go ahead and jump in. On Friday, day 7 of trial, they were going through the jury instructions in the morning. Defendant Brendan Banfield is accused of the murder of his wife and a third party, Joseph Ryan. And the prosecution's theory of the case is that the defendant set up a fairly elaborate scheme amidst his ongoing affair with his au pair, who is a co-defendant who has previously taken a plea deal and flipped and testified against him. The prosecution says that together they staged a third party, met through a website, staged to be Christine, to have an encounter, and they were setting that person up to make it look like he had broken into the home or gotten into the home and assaulted Christine Banfield. And then the defendant was going to come on in and break that up and shoot the other victim perpetrator. The defense said in an opening statement that there's a lot going on with police here, that the catfish theory doesn't fly, and that Brendan Banfield came home, saw someone assaulting his wife, shot them, and as he said on the 911 tape, he stabbed her, I shot him, he being the other victim. So we are now getting into the defense case in chief on stream next week. But on Friday, the attorneys were talking about jury instructions, and I've always told you how important jury instructions are. What the jury is told to consider matters tremendously in a case. And as they were talking about instructions, it came up that the prosecution had included instructions on heat of passion. It's something that we have not talked about in any of the cases that we've covered yet because it has not come up as a defense. But heat of passion is a defense that can be used to try to mitigate that first-degree murder down to a second-degree murder. But what does that rely on, everybody? Well, we're going to go to court and find out right now.
All right, Q is a malice instruction, which also goes into heat of passion. Do you have any objection to that?
I don't have it in that order,
If you're giving a heat of
Judge.
passion instruction, then wouldn't you be second-degree waterfall?
The next instruction after.
And yes, the court is talking to the prosecutor and the defense is still talking about something else. Yes, that's exactly what you're hearing. Correct. You're correct. That's what you're hearing.
I'm just asking a question here.
I'm sorry, Your Honor.
Your instruction Q has the definition of malice and also heat of passion.
Yes.
So if we're giving a heat of passion definition, that's a second.
And again, Judge, depends upon whether or not the defendant testifies. There would be a replacement for.
And you can see the court start looking towards defense table as the prosecution is like, well, Your Honor, we might need that instruction. but it's just going to depend on what the defense does.
Malice that does not include heat of passion.
Is the defendant going to testify, Mr. Carroll?
Yes.
Yeah, excuse me?
Yes.
He is going to testify.
Okay.
You can hear an audible gasp. I still don't know who in the courtroom gasped, but the fact that these attorneys can't hear each other and we can hear someone go in court is wild to me. But the defense attorney stands up and says very clearly, yes, the defendant is going to testify. And for those of you who are like, wait, I missed it. Somebody gasped. Yes, it might have been you too. But yes.
Is the defendant going to testify, Mr. Carroll?
Yes.
Yeah, excuse me?
Yes.
He is going to testify.
Okay. Then presumably depending upon what he says, this
Okay,
would
so
stand.
Q, so you don't have.
So the prosecution says, depending on what the defendant says, then we might need a heat of passion instruction. What could the defendant say that would lead to a heat of passion instruction? Well, walking into your bedroom with someone attacking your wife and then shooting them could allow a jury to reduce this from a first-degree murder to a second-degree, saying that the other victim was shot by the defendant's own heat of passion, that it was essentially a self-defense of others, that he felt that he had to do that and he had to act in that way. But the defense attorney, Mr. Carroll, did not very much look at his defendant to ask, did not ask his client anything again, just said immediately and straightforward, yes, he's going to testify. And I just have to wonder if that's why the defendant's been taking so many notes. You've asked me on stream, what in the world could he be writing? If the defendant has gone into this case planning to testify, saying essentially this is a defense of others case, that he thought that he needed to protect his wife with lethal and deadly force, then he's arguing. He did not stab Christine Banfield, and he did not shoot Joe Ryan with premeditation and essentially in a first degree or aggravated murder. That his shooting of Joseph Ryan was in defense of Christine Banfield. And the defense said in opening statement that Joseph Ryan stabbed Christine Banfield and that it was the defendant who came into the room while that was happening and shot Joseph Ryan, and that would not be a premeditated first-degree murder. So I think the defendant will probably follow through on saying that he's going to testify. One, his attorney didn't double check with him at all. It seems like this is the game plan going in. Second, unlike other cases we've seen where we've heard that the defendant is planning to testify, this defendant in opening statements has put forth a defense that could legally reduce the count of murder he's found guilty of if the jury finds him guilty from first degree to second degree. So rather than this just being a situation where if the jury believes him, he might be not guilty, which might happen as well, but this can also be the situation where the jury can reduce the degree of the crime if they believe him. We will see. But it gives the jury more options if he testifies, which is absolutely going to change the nature of this case going forward if the defendant takes the stand whenever court resumes. And when that happens, I will send you a law nerd alert. Because though we're going to leave a little bit of Zoom room, we're not going to leave Dave's a Zoom room when this man takes the stand. However, this case has been a bit disorganized. And on Friday, the judge commented on that as well. And for those of you who have sat with me through 4 days of trial in this case, this might feel a little cathartic taking a look at what Judge A said to the attorneys and the defense at the end of the day on Friday.
A couple things. Please use this extra time to reboot a little bit and get more organized. The wheels were coming off there, and I don't want to waste the jury's time anymore, or witnesses' time, or for that matter, my time. Just remember that you are responsible for your record to keep it clean, not me, not Shannon, okay? So please be wary of your exhibits and your numbers.
This whole case, we have seen issues with the exhibits, and I'm not surprised that the court has said the wheels were coming off. I need you all to get it together. You are responsible for your exhibits. The entire cross-examination of the co-defendant, the court was saying, is it this number? Exhibit number? Marked as? The court jumped in and did it every single time. So when we catch up to day 7, Friday, January 23rd of this trial, I think we're going to be condensing some witnesses. This seemed like it was a struggle of a day in court.
And what you are moving forward, I expect, and this is what I expect from all attorneys moving forward, I want all exhibits pre-numbered and in electronic format separately in separate files with the exhibit number already titled on that file. Okay? And make sure you have all your witnesses lined up and ready to go. Does that make sense to everybody?
It does.
Okay, we've got it. And make sure, Mr. Carroll.
We've got it. Looking directly at the defense. We've got it. We're good. We're on the same page, correct? We're here together, yes? Okay.
I think we need all your exhibits from today. Did we get the video to you?
Judge, your clerk kindly provided the one item. I am still missing all of defense exhibits today.
So we need to send
An entire day of trial where the defense exhibits were not given to the prosecution. What went down on Friday?
all the exhibits in those same separate files by exhibit number to the Commonwealth and also to us. When you send the exhibits to us, if they're not in the separate files are numbered, Shannon stays here for 2 hours to get it all done so she can take care of it. She can't leave until all.
Oh no, that is not the job of the clerk of court. It is not the clerk's job to renumber all your exhibits in digital format. Oh no. And they're running long court days. I mean, they've been running past 5 p.m. So for the clerk of court to have to stay 2 hours after court to fix what the defense attorney did not accurately submit, oh no. No wonder the judge is frustrated.
That is taken care of. So you have to get it to us as soon as possible to take care of, but I just need more organization. I really do. Okay? Does that make sense? Everybody get it? All right. See you next week.
And we need more organization too. So we're going to take advantage of some snow days, I think, and try to get caught up to this trial in real time, because it seems like the defense is close to calling their client, the defendant, to the stand. And I want to make sure we can watch that together. We'll see if things improve when we go back to court together in the prosecution of Brendan Banfield. Lawnard, we have to talk about something that has made my business life a lot easier in case you are in the same boat. Look, I love doing what I do, but as Team Baker grows, it requires me to do all the tasks that require lots of executive functioning, which is, perfect for me and all the ADHD. And that's where I rely on today's sponsor, Gusto. Gusto is an online payroll and benefits software built for small businesses. It's all-in-one, remote-friendly, and incredibly easy to use, so you can pay, hire, onboard, and support your team from anywhere. Like, do you have an employee who's due to watch sexual harassment training? Gusto's got it handled. Do you need new onboarding processes? Gusto's got it handled. From HR and payroll and keeping on top of the ever-present changes in any given state, Gusto's got you covered. And it's so easy to just log on from wherever you are, not just for you, but also for your employees, so they can take care of time cards and all of the things that they need, no matter where they are. It's no wonder that Gusto was the #1 payroll software according to G2 for the fall of 2025 and trusted by over 400,000 small businesses, including Baker Media. Try Gusto today at gusto.com/lawnerd. Plus, you get 3 months free when you run your first payroll. That's 3 months of free payroll at gusto.com/lawnerd. One more time, gusto.com/lawnerd. Let's get back to today's show. And looking at what's going on in Los Angeles, it's been a minute since we've talked, but we've talked about the investigation into the death of Celeste Rivas, the not yet 14-year-old girl that was found in the front trunk of singer and Twitch streamer David's Tesla back in September. We heard in November rumblings that a grand jury was underway. A grand jury can either continue to investigate a case or can be asked at the end to issue an indictment in the case, or both. And we have not heard much about what's going on in this case throughout December, which does not surprise me with the holidays and court schedules that we hadn't heard much. That is until Friday, January 23rd, when a friend of David's and another Twitch streamer was arrested, seemingly because he failed to appear on a subpoena for the grand jury. We are looking at the booking photo of Neo Langston, who is also a Twitch streamer, friends with David, or reported to be friends with David. We'll get into there's a photo of the two of them, and all of the reports I've seen are that they were friendly. I don't know, man. The Twitch streamers, I can't keep up. Frankly, I am a YouTube girly, but this, you will very quickly notice, is out of Helena, Montana. Yes, he was arrested in Montana on January 22nd and then brought to Los Angeles on January 23rd, where he has already bonded out. As I am recording this, looking at the Sheriff's Department Information Center, Neo Langston was brought into Los Angeles on the 23rd. He was booked at $23.27. His bond was set at $60,000. He was able to post that bond and was released on January 24th at 9:09 a.m. So he has already bonded out. He is not being held on a particular case. He is not being held on a warrant because he has a pending case of his own. From all the reporting I can find, he is being held because he failed to appear as a subpoenaed witness at a grand jury proceeding. And yes, that can get you arrested. So looking at local reporting out of Los Angeles, their headline says David's friend Neo arrested after failing to appear as grand jury witness, and cites that back to TMZ. They go on to say that singer David's friend Neo Langston was reportedly booked into jail after he failed to appear in court as a witness. TMZ reported Friday. They say Langston is a famous streamer. They go on to say that Montana officials told TMZ that Langston was arrested on a warrant after he failed to appear as a witness. He is allegedly being held without bond. Well, that's old reporting because once he was extradited, which took them barely any time at all, once he was extradited, we know that he was booked and released on bond. They go on to say that several witnesses have testified in front of the grand jury in Los Angeles, including the former tour manager. Jurors are likely to follow the lead of LA County prosecutors who want to see David indicted because they believe he was involved in the teen's death, and they are reporting that and attributing that back to TMZ. So will we see an arrest in the David case for someone responsible for or connected to the death of Celeste Rivas? And if they are looking at other friends of David, are we going to see other witnesses that failed to appear that get arrested? When we talked about that a while ago, we saw reporting from TMZ that they had overheard conversations in the courthouse hallway about witnesses being uncooperative. And we had that conversation then about whether or not body attachments would be issued, which is what this is, whether body attachments would be issued and held or issued and released. And if a body attachment is issued and released, they will go find where the person is, arrest them, and then bring them to jail and either hold them on bail or bond or hold them in custody until they go testify. Well, at least Los Angeles isn't going to be crippled by snow, sleet, and ice, so maybe this witness will end up in court on Monday. I'm going to be curious if he returns to streaming and what he says about this when he returns to streaming, because unlike other witnesses, I'm going to be very curious about the statements of those that are more active on social media after, well, they were found in Montana and dragged to court, because that's exactly what's happening here. So I'm very curious what Neo knows, what they think he knows, and what his testimony from the grand jury is going to look like. Thank you to today's sponsor, Brunt Workwear, because my son T has been using the Brunt Workwear boots and has been so happy and so comfortable. Look, not only do they come in a variety of styles, we picked the Marin because Travis could pick a more shoe layout instead of like the 90-degree heel, and he loves the wedge design of these boots. He loved how customizable it was, but right out of the box, these were super easy to wear for very long days. And that doesn't surprise me because Brunt was made to be comfortable out of the box with no break-in period at all. And one of the things I love about Brunt is that the founder, Eric Gerard, has named every product after guys that he grew up with. And that, I think, shows some of the heart of this company. And if you don't need a new pair of boots, don't worry. Brunt has heavy-duty pants, jackets, and more built for the real job site. So if you're sick of being forced to choose between comfort or durability, Brunt's got you covered. Brunt was tired of the workwear brands out there cutting corners. You work too hard to be stuck in uncomfortable boots that don't hold up. So they built something better, boots that are insanely comfortable and built for any job site. And for a limited time, Emily Show listeners get $10 off at Brunt when you use code LAWNERD at checkout. Just head to bruntworkwear.com and use code LAWNERD at checkout, and you're good to go. And after your order, if they ask how you heard about them, let them know it was the Emily Show. Let's get back to it. One thing I'm quite curious about is that there are photographs of Neo being arrested at what is reported to be his mom's house in Montana and taken into custody. How did they know? How was anyone waiting for this arrest to happen? So this is from a local reporter, Tom Bridge, and it said, here's the scene when police arrested Neo Langston in Helena, but they have numerous photos of him being cuffed and walked into police vehicles. So I wonder who let them know, because you don't want the suspect to know that you're coming to arrest them. So I wonder who let them know that he was being arrested. The Law Nerds are asking if I had seen any clips of him if he was streaming at the time he was arrested. I have not seen any clips anywhere on the internet if he was streaming when he was arrested. But how did media know that this was where police were going to be arresting him and that they were going to be arresting him at that time? They have photos from the moment he has walked out of the house and arrested. So coming from TMZ on the Bird app, they are reporting David's friend Neo Langston was booked into Montana jail Thursday on a warrant, according to online records, with a photo of Neo and David together. What's going to be interesting here is, was Neo with David in the days leading up to him leaving on tour? Because it seems that when David left on tour is when the Tesla was parked and then left before it was eventually towed. And then the remains of Celeste Rivas were discovered at the tow yard. So was he in and around the house, in and around the car, or with David in that time? And then that raises even more questions for me. Apologies for the end of the podcast being, but I have questions. But also, if he knows or was around, is he also a target of the investigation? And it would be unusual to have a target of the investigation brought before a grand jury as a witness, because they would have Fifth Amendment rights. So is this someone who could be a target of the investigation? Is this someone who might be given some level of consideration from the district attorney's office to say what they know? Is this someone who's going to immediately call a lawyer and just say, I'm not telling you anything, I know, I plead the fifth? Because depending on how much you know, are you an aider and abettor, or an aider and abettor after the fact? So I'm not sure where this is going to go and what we're going to see with this witness, but they were transported back from Montana a whole lot faster than Michael McKee was taken from Illinois to Ohio. So I don't know the differences in how extraditions work, but I don't know. Was LAPD just like, Montana, road trip, let's go? Just bringing them back together. I don't know, but we are going to have to wait and see. I have a lot of questions about this arrest, and I have a lot of questions about where this will go and if this witness will testify, if they will plead the fifth, if this is someone who the prosecution is interested in coming to an understanding with. I'm playing a little bit of, let's make a deal. Tell us what you know. And that might be why he was disinclined to respond to the subpoena and come to court. It also tells us that he was personally served with the subpoena and was well aware of it, because you can't issue a body attachment and a warrant to go arrest someone on a failure to appear without those steps being taken on that subpoena. So I have a bunch of questions on this one, but it's been a while since we've seen movement on the David case, and this is an interesting development. So when you see the headlines that there's been an arrest in the David case, now you know why. Hopefully it makes a little bit more sense. And, well, I wish I had more answers about that, but I think we've got some pretty good questions about that arrest and about what this witness might know. So Law Nerds, make sure you get the Law Nerd app so that you can see me in the chat. Take care of yourselves, take care of each other, and I'll see you in the next one. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.